Good afternoon. I'm Marianne Mason, the Dean of the Graduate Division, and I'd like to warmly welcome you to this Jefferson Lecture and to warmly welcome our guest, Harold Koh, this year's speaker. As a condition of the lecture, we are bound to tell you a little bit about this bequest. We have a number of graduate division lectures that have been the kindness of strangers in the 19th century or early 20th century have really added to the intellectual richness of this campus. In this case, the Jefferson Memorial Lectures were founded in 1944, one of the more recent ones, from a bequest from Elizabeth and her husband Cutler Bonestell. They were a prominent San Francisco couple who cared deeply for history and had hoped that the lectures would encourage students, faculty, visiting scholars, and others to study the legacy of Thomas and Jefferson and to explore the values inherent in American democracy. On the eve of the recall, I think we need special study about American democracy. Past lecturers have included Ambassador Jeane Kirkpatrick, Senator Alan Simpson, Representative Thomas Foley, Walter Lefebvre, Archibald Cox, and they've all delivered the Jefferson Memorial Lectures on early American history, about Jefferson himself, and on the American institutions and policies in economics, education, and law. And we are continuing in that tradition today. Before our lecture, I would like to thank Ellen Gobler. Ellen, are you here? Ellen, yes, who has been the organizer for this lecture and all the other graduate division lectures and has done a marvelous job. And now I'd like to welcome Orville Schell, the Dean of the Graduate School of Journalism and a member of the Jefferson Committee, to our podium to welcome our speaker, Harold Koh. Thank you.
Well, it's really an incredibly singular pleasure to welcome Harold Koh here. Let me tell you briefly just the hard facts about him and then say a few words about why I think for many of us he's been such an inspiring figure. Harold was educated at Harvard and Oxford. He's the La Trobe Professor of International Law at Yale. He's the author of several books, numerous articles, one of which was called Deliberative Democracy and Human Rights. He went to the State Department in the Clinton administration where he served as Assistant Secretary of State for Democracy, Human Rights, and Labor. There are other details one might mention, but I think what makes Harold so unique is that he has managed, I think as well as anybody I know, to combine theory and practice and to find that very interesting overlap where good scholarship and actually being involved in the world of law, of international human rights intersects. And it strikes me that the field in which he has done his research, done his teaching, certainly lends itself to that. And in this last 15 or 20 years, we've seen a quite amazing phenomenon in the world, the elaboration of this whole set of institutions of international law. Most recently, of course, the tribunals in Arusha for Rwanda, in The Hague for Yugoslavia, and now the International Criminal Court. All efforts which the United States has been somewhat chary of and stood back from in ways that I think is great pity. But this is the world of Harold Koh, and he's done a great deal to make the word flesh, to make theory practice. So please joining me in welcoming Harold.
Thank you, Orville, for that wonderful introduction. If you have not done so, I would urge you to read Aryeh Nayer's autobiography, Taking Liberties, which recalls when Aryeh, who was at the time the head of the executive director of Human Rights Watch, went with Orville's father, Orville Schell Jr., who was one of the co-founders of Human Rights Watch, to see Henry Kissinger. And when they saw Kissinger, Kissinger said, "Aren't you the father of the writing shells?" By which he was referring to the dean of your journalism school, Orville III, and his brother, Jonathan Schell, who's the author, of course, of The Fate of the Earth and The Unconquerable World. I don't know that there's any family in America that has contributed more to the cause of human rights. And what I wanted to just remind Orville was that I had actually met his father when I was a second-year student in law school. His law firm offered to take a bunch of us out to dinner. And by good fortune, sitting at this restaurant, which I very much wanted to go to, Orville's father started to regale me with stories about his work for Human Rights Watch. And at the very end of the dinner, he said to me, "Where do you want to work?" And now completely fascinated by his stories, I wanted to say I wanted to do human rights work, but remembering who was paying for the dinner, I said, "I want to work for your firm." And he said, "No, you don't." He said, "Do human rights work." And so it was with great pleasure that many years later, I was the head of the Orville Schell Center for Human Rights at Yale Law School. So I've quite literally am the only person other than Orville Schell III to carry his father's name. It's a great honor to be invited here to Berkeley. I knew that I had arrived in California when I checked into my hotel and saw a big button on the telephone that said, "Recall." And it's a very special pleasure to be invited to give this distinguished lecture, which has so many distinguished predecessors. I'm grateful to Dean Mason for inviting me, for Professor Harry Scheiber, and especially for Ellen Gobler of the Graduate Division for her wonderful hospitality, especially when I had to postpone this lecture from the spring because of an unexpected family illness. I should also say how touching it is to see many old colleagues, fellow classmates, former students, and former co-workers in the audience, including my friends from Bolt Hall, Jack McNulty and David Caron, and then two people who are very special to me, Nelson Polsby and Willie Fletcher. Nelson, who is, of course, the godfather of American politics, and Willie, who is, I think, the most distinguished judicial appointment of the last or any administration. Both of them have been longtime professors here and have been role models to me in more ways than they know. I come to you from Yale University, where even as we speak, our campus is consumed with watching the national collegiate finals of that most popular American game show, Jeopardy! And in case you haven't been following it, while the Yale student is, of course, the favorite contestant, a Berkeley student, Joyce Yuan, is also one of the finalists. And so I hope you'll forgive me if in that spirit I start this lecture not with a question and answer, but with an answer and a question. The answer is same-sex sodomy, affirmative action, North Korea, Iraq, Guantanamo, enemy combatants, the juvenile death penalty, and the International Criminal Court. Well, if that is the answer, what's the question? The question is, what are all features of transnational legal process after September 11th? Now, if the relationship between my answer and my question are not immediately obvious, I think I've got you for the next 45 minutes, so please sit back and make yourself comfortable and let me elaborate. I want to break this topic, transnational legal process after September 11th, into three parts, which are three questions that form the basis of this lecture. First, why do nations obey international law? Second, how do what I call transnational legal process contribute to national obedience with international law? And third, what role can transnational legal process play in affecting the behavior of several nations whose disobedience with international law has attracted global attention after September 11th, most prominently North Korea, Iraq, and our own country, the United States of America. And for shorthand purposes, I'll call these three countries the axis of non-obedience. So let me start. Why do nations obey international law? As you've heard, for most of my career as a lawyer, as a scholar, and also in the government, I've been focusing on the question, why do nations obey international law and why do they sometimes disobey it? And in my academic work, I've offered 5 cumulative explanations to that question. And I've reproduce them on this one-page diagram, which if you pull it out, I can just explain what it's all about. The 5 explanations are: first, reasons of power and coercion; second, reasons of self-interest; third, reasons of liberal theory, both rule legitimacy and political identity; fourth, communitarian reasons; and fifth, reasons of legal process. Now, to illustrate what I mean, let me ask a simple question. How do we make anybody obey the law? Even here in Berkeley, the height of global civilization, how do we persuade scofflaws to obey the law in a domestic setting? How do we get persistent litterers or traffic violators to follow the law? And if you ponder that question for a little while, I think you will come to the conclusion that the most complete answer is some combination of these 5 factors that I have identified. So, if you're faced here in Berkeley with a persistent litterer or traffic violator, you first threaten them with coercion, reasons of power. You threaten them with sanctions like a ticket or jail time, or you deny them benefits. No Pete's Coffee for you. Second, you tell them that it's in their long-term self-interest to obey the law, reasons of self-interest. Third, you invoke liberal ideas, Kantian ideas. You tell them they should obey the littering and traffic rules because the rules are fair, rule legitimacy, or because they should see themselves as law-abiding individuals, political identity. Fourth, you make appeals to community. You tell them we're part of the same community, and you ask them to act in the communal interest, not just in their narrow self-interest. And finally, I think violators obey for reasons that we lawyers understand best, which we call reasons of process. We try to enmesh law violators in processes, institutions, and regimes that force them to internalize the rules that we want them to obey into their internal value set. Well, as university citizens, we all know what is the tactic that works best when you have a student who has a disciplinary problem. The answer, of course, is you put them on the school disciplinary committee. Why? Because participating in the process of law enforcement makes the student both see why it's in his or her enlightened self-interest to obey the law, and it encourages them to try to incorporate this norm of obedience into their internal value set. And so if you want to see this played out intuitively in another setting, why is it that most people don't steal from one another? Not because of coercion or fear of sanction, but because over time, through a lifetime of participation in various processes, they come to internalize a normative set of values, a moral code or a religious faith, if you will, which makes them choose not to just to comply with the norm against stealing, but to actually obey it voluntarily. It's a pattern of obedience that's constitutive of who they become. Now, if you look at the right side of the diagram I've given to you, what I'm saying is that the real reason I don't burglarize my neighbor is not because of coercion or because of self-interest, but because I see myself as a person with an internalized moral code. In my case, it's a Christian code, but you could substitute Jewish or Buddhist or Baha'i or Muslim. Norm internalization and not coercion is the ultimate reason why most people obey the law. Well, if this is true locally, then I think it should also be true globally. And so the key to obedience with international law, in my view, is participation in process, or what I call transnational legal process. And as you see from my chart, there are 2 types of international process. One, so-called international legal process in the Benthamite sense, namely government-to-government process, horizontal process, where the main goal is compliance, first getting other nations to conform with international standards and getting them to comply. The other kind is what I call vertical process, namely when the goal is to force norm violators to accept norms into their internal value sets and obey them, to actually obey them, not just comply, but to obey them, what I call vertical process or transnational legal process. So the core of my approach is as follows. Why do most nations comply with the rules of international law? Most compliance comes from obedience. most obedience comes from norm internalization, and most norm internalization comes from participation in process, particularly transnational legal process. Well, that brings me to the second part of the lecture. What is transnational legal process? I think transnational legal process is a process whereby public and private actors, including nation states, corporations, international organizations, non-governmental organizations, and individuals, interact in a variety of forums to interpret, enforce, and ultimately internalize rules of international law, where, if I can repeat, public and private actors interact to interpret and ultimately internalize rules of international law. The key elements of this approach are interaction, interpretation, and internalization. Those seeking to embed certain norms into national conduct trigger interactions that yield legal interpretations that are then internalized into the domestic law of even resistant nation states. Now, let me illustrate by giving you some concrete examples. First, suppose you were a human rights lawyer in Great Britain, and you were protesting the treatment of immigrants who were being detained by the British government. What would you do? You would start by challenging the legality of the detention before the British courts, but suppose you lost. Is that the end of the story? Not anymore. Today, any British lawyer worth his or her salt would appeal the British court's ruling to the European Court of Human Rights in Strasbourg, an international body, and try to win a judgment invalidating the British government's conduct under European human rights law. To use my terms, you would trigger an interaction in a European court that would promote an interpretation of European law that would lead, you hope, to the internalization of that international rule into British domestic law. So your ultimate approach would not be a horizontal one, but a vertical one. Internalization of an international standard into a domestic legal system. Now, what does this have to do with our country, you say? Let me take example 2. In the early 1980s, it came to light that the Reagan administration was supporting the Contras in their struggle against the Nicaragua Sandinista government, and one of the means was to mine the harbors of the port of Corinto. In 1984, the Nicaraguan government filed a suit against the U.S. government in the International Court of Justice in The Hague. And many people assumed that this was just a publicity stunt, one which could have no conceivable impact on the United States. But what they didn't appreciate was that Nicaragua was not so much seeking an international judgment, it was seeking to enforce transnational legal process against its more powerful adversary. And the lawyer for Nicaragua was Abram Shays, the late Harvard International Law professor. By suing at this intergovernmental forum, triggering an interaction, Nicaragua had the goal of obtaining a judicial interpretation that the United States was violating international law, which it then hoped to internalize into U.S. domestic law. Well, it won a so-called provisional measures order, and then, instead of seeking enforcement from the World Court, the Nicaraguans went to Congress, the United States Congress, where then Senator Daniel Patrick Moynihan introduced a resolution which terminated future aid to the Contras for any actions that violated the World Court's ruling. And what happened? The Reagan administration stopped mining the harbors almost immediately. So in my view, what happened here was a different kind of appeal, not appeal to a judicial process, but appeal to a transnational legal process in which the Nicaraguans triggered an interaction which led to an international legal interpretation, which was ultimately internalized into U.S. Funding statutes or domestic law. And what did it do? It forced the most powerful nation of the world, the United States, into obedience. This brings me to a third example, the most prominent Supreme Court cases of the last term, the Texas sodomy case, Lawrence versus Texas, and the Michigan affirmative action cases, which were under the title Grutter versus Bollinger. Now, how are these like the examples I've just given? As most of you know, in 1986, in a case called Bowers versus Hardwick, the Supreme Court of the United States upheld the Georgia law, which outlawed same-sex sodomy between consenting adults. Now notice, the United States is not part of the European human rights system, so the losing attorneys could not, in any formal way, appeal the U.S. Supreme Court ruling to a higher court. But the U.S. is part of a transnational legal process, which is of good measure of its own creation. And so the lawyers tried to decide how they could use that fact to revisit this decision sometime later. It turned out that even at the time of Bowers versus Hardwick, the Supreme Court had ignored a European case called Dudgeon versus United Kingdom, which struck down the British prohibitions on same-sex sodomy. And since Bowers, the European Court of Human Rights had reaffirmed its Dudgeon decision, not once, but twice. So what the U.S. lawyers, particularly Lambda Legal Defense Fund, did was they waited and they provoked another interaction, this time at the U.S. Supreme Court level. And they asked the court to reconsider Bowers versus Hardwick. Now, Lambda asked me and some colleagues to write an amicus brief on behalf of the former UN High Commissioner for Human Rights, Mary Robinson, arguing that the U.S. Constitution's guarantees of privacy and equality encompass the international understanding found in the European human rights cases. And in his decision in Lawrence, which overruled the Bowers decision, Justice Kennedy wrote, quote, "To the extent Bowers relied on values we share with a wider civilization, it should be noted that the reasoning of Bowers has been rejected by the European Court of Human Rights. Other nations have taken actions consistent with the affirmation of the protected right of homosexual adults to be engaged in intimate sexual consensual conduct," citing our brief, and then said, "The right the petitioners seek in this case has been accepted as an integral part of human freedom in many other countries. There has been no showing that the governmental interest in this country in circumscribing that personal choice is somehow more legitimate." So in transnational legal process terms, Lambda triggered an interaction which provoked a constitutional interpretation by our Supreme Court, which effectively internalized European human rights norms into U.S. constitutional law. Now, to show that this wasn't just a fluke, only a few months earlier, in the Michigan affirmative actions cases, Justice Ruth Bader Ginsburg asked the Solicitor General, quote, "We're part of the world. This problem of affirmative action is a global problem. Other countries operating under the same equality norm have confronted it, Canada, European Union, South Africa. Should we shut that from our view, or should we consider what judges elsewhere have said?" The Solicitor General basically answered, "Shut your ears and not consider." And in rejecting that view, Justice Ginsburg's concurring opinion later in the case itself said, "The court's observation that race-conscious programs must have a logical endpoint accords with the international understanding of the Office of Affirmative Action, citing the International Convention for the Elimination of Racial Discrimination." By so saying, she was essentially arguing for internalization of the global standard on affirmative action into U.S. equal protection law. And to give another well-known example, the death penalty. As you know, the U.S. Constitution, 8th Amendment, bans cruel and unusual punishments. That has been construed in light of evolving standards of decency, marking the progress of maturing society. The Supreme Court has recognized in the 50s that that ought to be determined by reference to international as well as domestic standards. And in a number of Supreme Court cases, the court had looked to international opinion to decide whether conduct was or was not cruel and unusual. 2 terms ago in Atkins versus Virginia, the Supreme Court finally struck down the practice of executing persons who were mentally retarded. In doing so, they took note of the fact that within the world community, the imposition of the death penalty for crimes committed by the mentally retarded is overwhelmingly disapproved. Now, we also submitted a brief in that case. What we learned, much to our amazement, was that the United States and Kyrgyzstan were the only countries in the world that permitted the execution of persons with mental retardation. The only countries in the world. And when we filed the brief, the government of Kyrgyzstan immediately sent a letter to the New York Times saying, "In fact, we stopped executing people with mental retardation many years ago. Only the United States would engage in this barbaric practice." And we suggested that if only the United States does it, it is unusual for purposes of the cruel and unusual punishment clause. So again, using interactions, seeking a legal interpretation that internalizes a global standard into domestic law. That is the moment that we are looking for, the moment of norm internalization when domestic compliance becomes international obedience. Now, someone has asked me, or many people have asked me, is your notion of transnational legal process an academic theory? Is it an activist strategy? Or is it a blueprint for policymakers? And over time, my answer has become, it is all three. My time in the government confirmed a supreme irony, which I had suspected when I was a professor, that in the world of policymaking, those with ideas have no influence, and those with influence have no ideas. Too often we witness what I call the tragic triangle. Decision makers react to crises, but without any theory of what they're trying to accomplish. Activists agitate, but without a strategy about what pressure points they're trying to push. Scholars have ideas, but they lack a practical understanding of how to make those ideas useful to anybody else. And so we have decision makers making policy without theory, activists implementing tactics without strategy, and scholars generating ideas without influence. How do we bridge that? My belief is we can bridge the tragic triangle through the concept of transnational legal process. It is both a theory of explanation as well as a blueprint for action. So, for example, I don't believe the principles of international law are self-executing any more than I believe principles of medicine are self-executing. Anyone knows that if you want to use medical theories to make a patient's body better, you call a good doctor. And if you want to use legal theories to persuade a body politic to obey international law, call a lawyer who's skilled in the manipulation of transnational legal process. Well, that brings me to the third and final part of my lecture. How does transnational legal process, this concept, explain where we are after September 11th, particularly with regard to the three countries I mentioned earlier, North Korea, Iraq, and the United States? Let me start with North Korea. As everybody knows, North Korea is one of the most isolated countries in the world. It's also one of the biggest scofflaws. In 1993, North Korea faced a crisis because it could not provide power and food to its own people. But instead of addressing those core concerns, the North Koreans started building nuclear weapons. Now notice that the North Koreans, headed by that strange man, Kim Jong-il, is almost entirely outside the international legal system. So if you look at my list of factors, it made it very hard to appeal to them by invoking political identity, rule, legitimacy, or appeals to the international community. They did not feel like they were part of the international community. And so the Clinton administration was faced with a tough choice. And they decided to appeal to the North Koreans through a combination of self-interest and legal process. They decided that coercion was not a realistic option in a situation in which so many American soldiers and so many South Korean citizens would be put at risk by a military approach. And so they enmeshed the North Koreans in a multilateral framework, the so-called agreed framework, in which the United States, South Korea, and Japan would engage North Korea diplomatically with a single message. If you give up your nuclear program or reduce it, we'll give you, in return, involvement in the international community, food, electrical power, and the expansion of cultural and economic links. The hope was that by enmeshing the North Koreans in this framework of processes, institutions, and regimes, the North Koreans would come to see their self-interest as working within the system, would come to develop a more law-abiding political identity, would come to internalize a rule of nuclear restraint into their internal value set, and change from a law-violating to a law-abiding approach. So what happened? Well, the agreed framework functioned for about a decade. There is no doubt that the North Koreans violated, but it's also no doubt that it had a restraining effect on North Korea's nuclear behavior. Deputy Secretary of State Richard Armitage recently said, if there had not been a framework agreement, there would be dozens of nuclear weapons that North Korea did not produce. The North Koreans placed moratoria on tests of long-range missiles. They admitted that they had kidnapped Japanese citizens. They allowed greater inspections. They started a bilateral dialogue with South Korea's Kim Dae-jung. And in November 2000, they met in Pyongyang with a delegation from America led by Secretary of State Madeleine Albright, and I was lucky enough to be on that delegation. Now, my point is that even if this transnational legal process approach did not work perfectly, it was working. And what it did was it started a transnational process that I think could have led to the internalization of norms into the North Korean system. It was based on the right idea, using process to get the North Koreans to accept international norms as part of their internal value set. Well, what happened? In January 2001, the Bush administration came in and abandoned this approach. They stopped negotiating. They decided that Kim Jong-il was part of the axis of evil. They began making coercive noises. They named North Korea as part of the axis of evil, a list of 3 countries, and then they attacked the first country on the list. Well, I've met Kim Jong-il now. I can tell you he is strange, he is cruel, but he is not stupid. And when you're on a list of 3 and the first country has been attacked, you may decide, well, that he should gain leverage by resuming the process of rebuilding nuclear weapons, which is what he did. And that led to the intolerable situation in which the North Koreans were going nuclear and we were doing essentially nothing about it. And so, after a long period of time, what's happened, the administration has finally returned to, you guessed it, a transnational legal process approach based on self-interest. A number of years later, we have re-engaged the North Koreans in a multilateral diplomatic framework, which is going on as we speak. It has elements of the old agreed framework, but it seeks to be more verifiable and less susceptible to North Korean blackmail. In short, we end where we began, with a transnational legal process approach. Well, what do I say about Iraq? Well, much the same analysis applies. Saddam Hussein ranked right up there, as you know, with Kim Jong-il as one of the gross violators of international law, of human rights treaties, of disarmament treaties, of ceasefires. And in 1991, in the Gulf War, the U.S. and its allies used coercion, but within a framework of international law, to force Saddam Hussein to leave Kuwait through Security Council resolutions that created an inspections regime. That inspections regime worked, and then it atrophied until we got into a situation of massive Iraqi non-compliance. In the early days of the Bush administration quarreled within itself and finally decided to continue to work within the legal process framework. They went to the UN General Assembly, said we're ready to use coercion if necessary to enforce international law. And with the cooperation between Tony Blair and Colin Powell, they brought this issue into the Security Council framework and achieved a unanimous resolution, Resolution 1441, which is a classic piece of transnational legal process. It was an interaction that generated an interpretation that Iraq was in material breach of international law and set up a process of inspections, which was a public trial of disarmament-type facts, which went on with the goal of internalizing a norm against weapons of mass destruction into the resistant Iraqi system. Now, it's important to see 2 things. In hindsight, this approach was working. The transnational legal process approach was working. Whatever weapons of mass destruction were being held in Iraq were being removed. For whatever reason, we don't know. Normal internalization was working. And moreover, the transnational legal process approach took the administration down a legal path much further than they would have preferred. At first, if you remember, the Bush administration said we don't need any Security Council resolution. Then they got Resolution 1441. Then they said we don't need to do inspections. Then they pursued inspections for 4 months. Then they said we don't need a second Security Council resolution. Then they tried to get a second Security Council resolution. And then, bad luck, it broke down. Last spring, the administration, feeling the pressure of its own military timetable, got into a destructive game of chicken with Jacques Chirac. And then the 2 presidents, Bush and Chirac, issued incompatible proclamations. The French said, we will veto any resolution that calls for use of force against Iraq. President Bush said, I'll go to a war whether I get a second resolution or not. That created a zero-sum situation where the only resolution the U.S. thought was relevant, namely one authorizing the U.S. to attack, was the one that the French were pre-committed to veto. And then because of this impasse, it was pointless to seek the support of the countries who would make up a Security Council majority. Why? Because even close U.S. allies like Mexico or Chile were not willing to subject their citizens to controversial votes that they knew would be meaningless, since the United States would either go to war anyway or the French would veto what they did. And so the United States abandoned the request for a second Security Council resolution. They attacked Iraq with the support of a coalition of the winning. They won a smashing military victory. The president declared major combat operations over, and you know what's happened since. 1,700 U.S. troops have been wounded, including 4 more yesterday, 2 more killed. And now we're trapped in a black hole in which the United States is asking for $87 billion to rebuild Iraq. The United States is willing to contribute $20 billion of that. The UN is willing to contribute $2 billion, and nobody knows where the rest of the money will come from. Maybe Arnold does. So what's my point? A transnational legal process solution toward Iraq was available, and it was bungled. Who do I blame? I blame Saddam for his venality. I blame Chirac for his obstinance, which, by the way, has crippled the United Nations Security Council. But most of all, I blame the Bush administration for framing this in bipolar terms. They said the choice was attack or accept the status quo in which Saddam is building weapons. But in fact, there was a third way: disarm Iraq without attack, through transnational legal process, through multilateral disarmament, through enhanced containment, through aggressive human rights intervention that would have driven Saddam out and into a system of accountability, a so-called Milosevic-type solution. They could have made a situation in which Iraq could have been disarmed through multilateral inspections under a UN scheme, and Saddam could have been brought to an international war crimes tribunal of the United States making. Why didn't that happen? Because the United States opposed the creation of a tribunal. In fact, the United States opposed an international criminal court and then announced to high Iraqi leadership, you will be prosecuted, raising the obvious question, where? Where? Now, what the United States, I think, failed to realize was that a legal process approach would have allowed it to oust Saddam without attack, rid Iraq of weapons of mass destruction, promoted human rights, kept us within a legal framework, left open the possibility of UN support for the reconstruction effort, and held Saddam accountable. Instead, the United States rejected those and left itself with a coercive, unilateralist approach, which has now diminished its capacity for global leadership under a rule of law banner. Well, I've already now told you about part of the problem that the United States has faced as a member of the axis of non-obedience. And the greatest surprise to all of us, I think, should be how quickly, since September 11th, we have turned the story from the non-compliance of others with international law with our own non-compliance. Why did this happen? We all know of 3 obvious examples: the U.S. unsigning of the International Criminal Court Treaty, seeking exemptions from U.S. troops from ICC jurisdiction. Second, the U.S. attitude toward the Geneva Conventions and its decision to create zones in Guantanamo where people are being held without Geneva Convention rights, as well as designating certain U.S. citizens within the United States as enemy combatants. And third, the death penalty, which has become a growing irritant in the relationship between the U.S. and the EU, even in the war against terrorism. And most recently, we have the British and Australian insistence that their citizens on Guantanamo not be subjected to the death penalty. Now, if, like me, you're watching these events, Guantanamo, the ICC, enemy combatants, you're wondering, isn't this part of something bigger? And if that's what you're thinking, you're right. What we're witnessing is nothing less than an assault by our government on the system of transnational legal process that we created since World War II to serve our own national interests. I like to think of the image of a legal exoskeleton, a legal exoskeleton. After World War II, the United States constructed a world public order devoted to liberal internationalism. Its effectiveness was muted by the intense bipolarity of the Cold War, but after the Berlin Wall fell from 1989 to 2001, there was an era of global optimism in which the U.S. tried to revive the idea of using global cooperation to solve global problems, like war crimes, like global warming, trade imbalances, democracy, development, AIDS, transnational crime and drugs, you name it. And so the approach adopted by the U.S. was more diplomacy, more human rights, more democracy, more legal process. Then came 9/11, the classic example of a global problem to be solved by global cooperation. And the administration then in power, the Bush administration, responded not within the existing post-war framework, not within the legal exoskeleton, but they tried to create a new architectural counter-response, the Bush Doctrine, if you will. And 2 years later, we see its shape, 5 parts. First, Achilles and its heel. The United States becomes intensely aware that, like Achilles, we are a superpower, but with super vulnerability. And so we need to use our superpower status to protect our vulnerability. And what's our approach? Number 2, homeland security, in both a defensive and preemptive sense. Domestic security, immigration control, security detention, information awareness, even while we assert a novel right under international law to forcibly disarm any country that presents a gathering threat. Third, a shift in our focus on human rights. Franklin Roosevelt had set the standard for human rights by talking about the 4 freedoms: freedom of speech, freedom of religion, freedom from want, and freedom from fear. Administration officials in this administration have now said there's only one freedom that counts: freedom from fear. And as a result, they've now created a 2-pronged strategy of extra-legal zones, prominently in Guantanamo, where no law applies, and extra-legal persons, enemy combatants who are U.S. soldiers on American soil. Fourth, we have a shift in the strategy of democracy promotion from what we call bottom-up democracy to top-down democracy, democracy imposed by military invasion and prolonged occupation in Afghanistan, in Iraq. And finally, to implement this administration has shifted. If the Clinton administration pursued what my friend Strobe Talbott called strategic multilateralism and tactical unilateralism, the Bush administration has shifted to a strategy of strategic unilateralism and tactical multilateralism. What's wrong with this approach? 3 things. First, instead of it promoting universal values, the U.S. promotes double standards by which it is on a separate track from other countries. Second, by engaging in this unilateralism, the U.S. has diminished its standing in the international regime in which it takes part, limiting its soft power or its power to persuade. This is exactly what we're seeing now with our incapacity to mobilize countries to help us to rebuild Iraq. And third, it converts us from a major supporter of the legal exoskeleton into the major outlier trying to break free of the very legal framework that we created. Well, if this is my diagnosis, that the U.S. has not made enough use of transnational legal process with regard to North Korea, Iraq, and America's own conduct, what's the solution? Quite simply, the U.S. and those engaged and committed to the rule of law should invoke transnational legal process more in each case. In North Korea, as I've already said, the solution to the situation is clearly another agreed framework, a transnational legal process solution. It is norm internalization. In Iraq, now that we have occupied Iraq, what is our goal? To use a domestic constitution that internalizes international human rights norms to change the character of the country. It's a legal process, norm internalization strategy. And what about the U.S.? On the one hand, we're the toughest case because we're the most powerful nation in the world. On the other hand, there are so many channels through which norms can seep into U.S. law that the U.S. may ultimately be the most subject to international influence. The U.S. may want to break free of this legal exoskeleton that we created, But already that legal framework is pushing back. You can see it now in the debate over the UN Security Council resolution. And let me quickly illustrate and then conclude. For example, with regard to the International Criminal Court, this administration unsigned that treaty. But I think what we should realize is that every future act by which the U.S. cooperates with the International Criminal Court is a de facto repudiation of the political act of unsigning. The prosecutor's office in the ICC can internalize guidelines for responsible prosecution. Advocates of the ICC within the United States can try to develop support for it. And most of all, the U.S. government could engage in case-by-case cooperation with the ICC over particular cases, like in the Congo, or over provision of classified information. With regard to the Geneva Conventions, we are now seeing this issue being litigated in a variety of forums, not just U.S. courts, but in the Inter-American Commission on Human Rights, before the British courts, with the idea of essentially demonstrating that the U.S. conduct is not only inconsistent with the Geneva Conventions, but is also inconsistent with U.S. national interests of our own soldiers who might someday be held as POWs. And as I speak, there are two cases working their way to the Supreme Court, the Jose Padilla case in the Second Circuit and the Yasser Hamdi case in the Fourth Circuit, which I think will test whether our Supreme Court will internalize these international standards into U.S. law. And how about the death penalty? As I speak, advocates of transnational legal process are bringing suits against the United States. In fact, it's the Mexican government which is doing so in the World Court. And there's litigation before the U.S. Supreme Court on the core issue of the juvenile death penalty. In fact, in the week since Lawrence versus Texas was decided, one federal district judge has already cited Lawrence to question whether the federal death penalty can be reconciled with constitutional barriers against executing people who are innocent. And the Lawrence approach now clearly is running counter to America's penchant for executing juveniles. The fact of the matter is that the United States and Somalia are now the only two countries in the world that permit the execution of juveniles, in the sense that they have, are the only two countries that have not signed the UN Convention on the Rights of the Child. Since 1989, the U.S. has carried out more publicly reported executions of juveniles than any other country. In 1999, the only country other than the U.S. to execute a juvenile offender was Iran. From 1994 to 2003, 20 child offenders were executed in 5 countries: Congo, Iran, Pakistan, Nigeria, and the leader, with 13, the United States. And even within the United States, 7 states have committed most of the executions, and in fact, 2/3 have been committed by Texas and Virginia. Texas and Virginia lead the world in executing juveniles. Now, this strikes me also as unusual in terms of the cruel and unusual punishment clause. The Missouri Supreme Court just struck down the juvenile death penalty in a case that I think is likely to go to our Supreme Court. It will be another challenge for a transnational legal process. I should say it's complicated by the fact that the DC sniper, the younger one, John Lee Malvo, who's just been indicted in Virginia, is also a juvenile, and that 3 of the people on Guantanamo are juveniles, including a 13-year-old who's accused of having committed an act of terrorism in Afghanistan. So this is where the battleground will be. In the ICC, on whether the United States will cooperate on a case-by-case basis, on the Geneva Conventions in the U.S. courts, and on the death penalty in the also in the U.S. courts, but citing international opinion. The question is whether interactions can be brought that will lead to interpretations that will internalize these global norms into domestic law. In closing, let me say, I hope I've convinced you that same-sex sodomy, affirmative action, North Korea, Iraq, Guantanamo, enemy combatants, juvenile death penalty, and the International Criminal Court are all features of transnational legal process after September 11th. But increasingly, in a post-9/11 world, I believe we're facing a new kind of jeopardy, to coin a phrase. On the one hand, the United States has recognized and urges the need for norm-based approaches to international law and norm internalization. On the other hand, the United States is trying to break free from the very legal structure, the very legal exoskeleton that it created, by pursuing coercive theories of power-based internationalism. To see this tension between norm-based internationalism and coercive power-based internationalism, all you have to do is listen to President Bush's speech last week before the UN Security Council. I, for one, believe that as a nation that's conceived in liberty and dedicated to inalienable rights, the United States has very strong impulses to address the world not just in the language of power, but in the language of power coupled with principle. And I think that we, as scholars and lawyers and activists who care about the rule of law, should not just be bystanders at this pivotal time, but we should do what we can to use transnational legal process after September 11th to prod this country that we love to follow the better angels of our national nature. Thank you.